Welcome to Family Law Talk. Family Law Talk. Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a multi-state family law firm. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today, and the topic is an estate planning topic titled Pour-Over Wills Explained, Connecting Your Will and Trust. And this episode today is based on an article on our blog, familylawheadquarters.com, dated March 30th, 2026. And the title of that article is Understanding Pour-Over Wills, How They Work with Revocable Trust. So as a follow-up to the episode today, go on over to familylawheadquarters.com and read this article for more information. All right, most individuals know what a simple will is. A will can be an important document for individuals. If they have a simple will, that simple will upon their death is to be submitted to the probate court. The estate is then administered through the probate court process, which can be expensive, tedious, and cumbersome because it's overseen by the probate court itself. All right, so most individuals know what a last will and testament is. A lot of individuals come into a law office wanting a last will and testament, but they don't fully understand the probate court and how it works and how it's tedious and how an individual's heirs then have to deal with the probate court in order to get their share of the assets is outlined in the will. All right, another way to do this is through a pour-over will, which a lot of individuals have no idea what it is, okay? A pour-over will is used in conjunction with a revocable trust. So an individual creates a revocable trust. It could be called a family living trust or something like that. And what the pour-over will does is it works alongside that revocable trust. And the primary function is a little bit different than a last will and testament, like just a simple last will and testament without the revocable trust. All right, what the pour-over will is supposed to do is pour over the assets into the revocable trust. So it acts, if you will, as kind of a safety net. So all the assets hit the safety net, and then they pour over into the revocable trust, and then the assets are distributed according to the terms of the trust itself and without the oversight of the probate court, okay? So that's the point and the purpose of a pour-over will, which is to get the assets out of probate and into the revocable trust. All right, a lot of individuals then are confused about revocable trust. What is that? Again, a revocable trust is sometimes referred to as a living trust, and these are kind of the same thing. It's just synonymous terms, but assets are held by this legal entity created during an individual's lifetime to hold the assets. And then within the trust, there's typically a trustee. An individual, while they're alive, is typically the trustee, and they maintain full control over the property within the trust. All right, one of the primary advantages of a revocable trust is that the assets that are properly transferred into it during the lifetime avoid probate upon passing. And so this can make the transfer of assets upon death more efficient. It can make it more private. It can actually result in less attorney fees on the back end because the heirs don't have to deal with the probate court, or at least the extent to which they have to deal with the probate court is minimized. All right? Again, the goal is to take the assets and pour it over into the revocable trust. All right? So again, let's break this down in a little bit more detail. Simple will versus trust-based planning, okay? So a simple will alone requires that the assets pass through probate, so that will has got to be filed with the probate court. The probate court then supervises the process in terms of distributing the assets and paying the debts of the estate, okay? So this can involve delays, additional cost. Typically, public notice has to be published to give creditors time to file any claims against the estate that they want to file. So if an individual owed money to various debtors, and they can file claims against the estate, These debts are then paid before assets are distributed. So again, it delays this whole process. Whereas if there's a revocable trust paired with a pour-over will, then this is going to allow many of the assets to pass outside of probate just through the trust terms, which can help streamline the process. It maintains privacy, and it can really reduce a lot of the complications, all right? Another question lots of individuals have is the cost considerations. And what individuals need to look at is upfront versus long-term. Okay, the truth is upfront, a simple will is probably going to cost less, right? Less expensive. So a lot of individuals can gravitate toward having the simple will because it's not going to cost them a lot of money. In contrast, a revocable trust with a pour-over will is typically going to involve higher upfront legal fees because there's more document drafting that has to take place. And so, some individuals can shy away from it when they hear this. But the reality is on the back end, there's a savings because on the back end, there's less interaction with the probate court, which is going to keep fees down. So individuals, when they're weighing this, have to think of the long term. In the long term is that the pour-over will with a revocable trust is often going to save money and hassle. Okay, one of the other things individuals need to think about is, do they want to make things easier on their heirs? So if they want to make it easier on their heirs, a pour-over will and a revocable trust is going to help that ease. Right? Loved ones aren't going to have to deal with the probate court or at least not deal with it nearly as much. And so that can be a good thing for them. Whereas if it's a simple will and that has to be filed with the probate court, again, it's going to be more time, more hassle, more fees, and it's going to take them a longer period of time, typically, to get their share of the estate. Okay, so just some final thoughts. A pour-over will is not a standalone solution. Okay, you wouldn't just have a pour-over will by itself. You have to have the pour-over will with the revocable trust. These two things work in tandem. All right, and these are tools that can really help keep assets out of probate and make things a lot easier on the heirs. And yes, they can cost more money on the front end, but on the back end, it can save a lot of money. It is typically worth having. So look, every situation's different. Every situation's unique. Some individuals might just want a simple will, even in hearing this podcast today, but individuals ought to at least think about having that pour-over will with the revocable trust. It makes things a lot easier on the back end for heirs, and it keeps the assets out of probate. Obviously, there's a lot of other intricacies with revocable trust as well, like certain assets need to be titled in the name of the revocable trust during the individual's lifetime. So again, bank accounts could be titled in the name of a revocable living trust. A lot of assets could be transfer on death, payable on death to the revocable trust, for example. So these assets then go into the trust. If that's not the case, and the assets don't enter into the trust, and then the idea of avoiding probate doesn't occur. So it's really important to speak with a lawyer about how you title all your assets if you've created a pour-over will and a revocable trust, because you want to make sure you've done all the titling you need to do. Another big tip is, look, after a divorce, so if you create this during marriage and you get divorced, then you're going to probably want to update your pour-over will and revocable trust, because when individuals are married, or when couples are married, they typically leave, a good chunk of their assets to their spouse. But after they get divorced, they probably don't want that anymore. So a good time to have a lawyer relook at your estate plan is right after the divorce as well, to make sure it's updated accordingly to account for the fact that you are now divorced. All right, so that's the episode today. Again, as a follow-up to the episode, going over to my blog, familylawheadquarters.com, dated March 30th, 2026. The title of the article is Understanding Pour-Over Wills, How They Work with Revocable Trust, and this will give you more information on this topic. But thanks for tuning in today. Stay tuned to our next episode of Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision and should not be based solely on advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtained in this podcast is not, nor is it intended to be, legal advice. You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. Past results afford no guarantee of future results, and every case is different and must be judged on its own merits. Kirk Stange is responsible for the content. Headquarters, Office, 120 South Central Avenue, Suite 450, Clayton, Missouri, 63105. Kirk Stange is licensed in Missouri, Illinois, and Kansas.